Manny Fitzsimmons. I'm a Washington Realtors Legal Hotline lawyer, and today's discussion is another in our series entitled Real Estate Fundamentals You Should Know. And really, you should know this one because I get this question from time to time. Not too often, thank goodness, but I get this in a situation where brokers are trying to be clever and they're trying to outsmart the forms. And the question goes something like this. Buyers, let's say it's a home sale contingency, Form 22B. Buyer's bump is 48 hours. Not 2 days, but 48 hours. When does buyer's bump expire if our calculation is using 48 hours instead of 2 days? The only answer that I can give to that question every single time is, I have no idea. Because the statewide forms are not set up for calculation of time using hours. The statewide forms are set up to compute time using days. And there are many good reasons why that's a true statement. Let me go over a few of them. Most signatures are delivered in today's world by electronic means. If we're calculating time periods by hours, then it's important not only to establish the day on which a form is delivered, but the exact time by which the form is delivered. So ponder this question for a minute. Let's stick with our analysis of the buyer's home sale contingency. Let's say that seller accepts a competing offer, subject to the buyer's bump, at 9 a.m. on Thursday morning, and listing broker immediately delivers that by electronic signature to buyer's broker. Buyer's broker, however, is out showing houses and doesn't get that email until 3 p.m. Now we have this expanse of time from 9 a.m. to 3 p.m. We've got 6 hours from when the listing broker sent it to when the buyer's broker opened it. When do those 48 hours start? If we're counting by days, then we know that we start counting by counting the day following the triggering event. And the triggering event is the date of delivery, and then we would start counting the next day. So in the analogy we just gave, the date of delivery would be, I think we said Thursday, because it was 9 a.m. that it was sent, it was 3 p.m. that it was received, but it all happened on Thursday, so day one is Friday. If we are counting in hours, when do we start counting? I don't know. The only answer I can give you is I don't know. The next question is, if we're talking about 48 hours, are those hours included in business days only, or would they also include weekends and holidays? Now, if you read the computation of time provision in the purchase and sale agreement, it says that any time period of 5 days or less includes business days only. Well, 48 hours is certainly less than 5 days. So it might be easy to say, well, even the 48 hours then is only business hours. But if that's true, then why did we use the characterization of hours instead of days in the first place? What was the intent of the parties in using hours rather than days? And that's the question that has to be answered in analyzing whether or not the 48 hours includes business hours or only or not. Then the question is, can the time period end on a weekend or holiday? Well, the form says for any time period counted in days, no time period can end on a weekend or holiday. Well, if we're counting as 48 hours, is that equivalent to 2 days? So therefore we're counting in days even though it says 48 hours? And the answer is, I don't know. And the problem with all of this is that real estate brokers, you are licensed to fill in the blanks on pre-approved, lawyer-drafted, standardized forms. The form that you are authorized to use is, in most cases, the statewide form. The statewide form computes time in days. When you add language that calculates time in hours, you are held to the standard of care of lawyer in doing that. A lawyer is not going to add a time calculation or a time provision that not only competes with, but in some respects conflicts with the boilerplate language of the forms. And so the question would be, if you are including provisions that count time periods in hours instead of days, have you drafted that purchase and sale agreement in keeping with your requirement to conform to the standard of care of a lawyer? The answer to the question is you know, you created a provision that I, as the hotline lawyer, can't begin to tell you what it means. It doesn't make sense in light of the boilerplate language of the forms. If it's so important to create a time period that is for 2 days only, and those 2 days include business days, because that's really what most brokers are trying to do. When they say 48 hours, my understanding from talking to them is what they're really trying to do is they're trying to create a 2-day period that's reliably a 2-day period, notwithstanding the fact that it might include a weekend or a holiday. Well, then you know what? Say 2 days and figure out a way to write language that says it's 2 business days, notwithstanding the computation of time provision. Don't, however, try to include a provision that calculates time in hours, because it does not work in the statewide form system. If you have questions on this, send an email to me, or if you want to just talk about any other topic related to real estate law in Washington State, send an email to me. Legal hotline at warealtor.org. Thank you for being a Washington Realtors member.